Good afternoon. We're going to go ahead and get started. Welcome, everybody. Before I introduce our speakers, I just wanted to mention that some of the topics that they will cover today have certainly been tackled by Minnesota courts in the past and are likely to appear in front of Minnesota judges in the future. And the purpose of the presentation is not to influence anybody in this room who might potentially be working on an expungement case, but more for them to talk about their organization and the kind of issues that they tackle. Emily, with her work to educate the public about the large number of citizens who have criminal records and how that impacts their lives, and Josh to talk about some of the changes in expungement law and how in some aspects it's still a limited remedy for people. So I'd like to introduce our speakers. Emily Baxter is the director of We Are All Criminals and a fellow at the University of Minnesota Law School's Rovina Institute of Criminal Law and Criminal Justice. Prior to this, Emily served as the director of advocacy and public policy at the Council of Crime and Justice in Minneapolis, and was an assistant public defender representing indigent members of the Leech Lake and White Earth bands of Ojibwe, charged with crimes in Minnesota State Court. Emily is a former Archibald Bush Fellow, and her project, We Are All Criminals, which challenges society's perception of clean versus criminal, can be found at weareallcriminals.org. Josh Esmay will speak second. He is the current director of public policy and advocacy at the Council of Crime and Justice. In this role, he facilitates fair hiring trainings with employers, employment specialists, and criminal justice personnel. He's an individual overcome legal barriers created by criminal records and develops the council's policy, agenda, and outreach. Josh graduated from the University of Minnesota Law School, began his career practicing at the Ramsey County Public Defender's Office, and he also serves as the co-chair of the Second Chance Coalition and is president of the Minnesota Community Corrections Association. So please help me welcome Josh and Emily.
Hello. A couple of years ago, I got a phone call from a woman. She wanted to tell me a story. Years ago, when she was 15 years old, she said she was something of a nerd, a chemistry buff. And one bored July day, she and some of her nerd friends decided that they would make their own homemade napalm. Like, what else does one do when they're 15 and bored, right? Well, hopefully not too many do this. She and her friends whipped up this highly flammable, viscous gel in an apple cider glass jar. Then took it out to a state park where they found the small, ideal enclosed space upon which they could test their substance. They doused the inside of the porta potty with this gel, lit a tennis ball on fire, lobbed it in, and watched it glow. They then ran back to their cars and drove the speed limit the entire way home, terrified of what had just happened. The day that I interviewed her, she had been keeping a 3-month-old heart alive with her index finger, feeding it for the baby. She's a pediatrician. In this state and in many others across the United States, had this woman been caught, she would have been permanently barred from ever working with you. She would have been permanently barred from ever working with vulnerable populations because it was the destruction of a structure with a homemade explosive. But she wasn't caught. This woman is a pediatrician, and for me, it highlights the waste, if you will, in this state and beyond, when we're foreclosing futures before brains are even fully developed. These are the stories that I want to talk to you about today. The stories of people who have gotten away with crimes. And while we'll look at these incredible stories at times, and sometimes they're boring stories, and sometimes they're silly stories, and sometimes they're somewhat terrifying stories, we'll also be looking at the stories of individuals who have been caught, and who now, in the months and years and decades later, are still being punished for the exact same behavior of those who got away with it. But first, let's make sure that we're all on the same page. This is a graph taken with statistics from the Bureau of Justice, data from the Bureau of Justice Statistics and from the Sentencing Project's Trends in U.S. Corrections. And you can see that this is the U.S. state and federal prison population between 1925 and 2013. And for the first part of this graph, in fact, for the majority of this graph, barring for general population growth, it really doesn't change that much. And then something happens, a spark. Something changes in the 1970s, really picks up speed in the 1980s, and just explodes in the 1990s. That led to this incarceration boom. What do you think are some of the policies and practices that may have contributed to that? The war on drugs. Most definitely, I think, is one of the greatest contributors to our current carceral crisis. What else?
3 strikes and you're out.
3 strikes and you're out. Mandatory minimums, absolutely. The idea that we need to be tough on crime rather than smart on it, right? Policy after policy and practice after practice contributed to this. But really, this is just a drop in the bucket, right? The people that we have currently in cages, those who are in prison and in jail, it's really just a small portion of the overall problem. For example, turning back to this graph, again, it is the U.S. state and federal prison population between 1925 and 2013. It is not our jail population, the millions of people that we have in county and parish jails. It is not the millions of people who are on probation or parole, those who are under the thumb of the criminal justice system, their liberties curtailed, and yet they are not shown here on this graph. It also doesn't show those who are on immigration holds, those who are in mental health facilities, and those who are in juvenile detention. They are not shown here on this graph. And it doesn't show the 65 million people across the United States who have a criminal record, those who have been involved in the criminal justice system and who carry that burden with them. They are not shown here on this graph. And just as importantly, this graph does not show the nearly 3 million children, the sons and daughters, the brothers and sisters, the mothers and fathers, the spouses and partners, and greater community members who are all profoundly impacted when somebody is taken out of the home and then not allowed back in. They are not shown here on this graph. And so while this looks like a tsunami ready to crash upon our shores, you realize that this is just a drop in the overall ocean of a crisis that we're dealing with. It's at no small cost that this comes. Across the United States, we spend more than $80 billion a year on correctional control. But that cost is just something that can be balanced in an Excel spreadsheet, right? It doesn't include what communities spend to house, train, educate, treat, employ, and otherwise transition individuals who are leaving prison or jail. And that is a cost that falls disproportionately upon poor communities and communities of color. For example, across the United States, there are more than 12 million arrests each year. 80% of those individuals who are arrested are eligible for a public defender. In some jurisdictions, that means that you make less than $3,000 a year. Can you fathom that level of poverty? Not can you fathom that it exists, because I think we're all bright enough for that, but can you personally fathom living on $3,000 a year? Likewise, it disproportionately impacts communities of color. For example, the lifetime likelihood of imprisonment for black men is 1 in 3. For white women, such as myself, it's 1 in 111. Now that is a far greater cushion. Not to say that white women aren't committing crimes, right? But proportionately speaking, that's not who you see in our criminal and juvenile justice system. As far as that juvenile justice system is concerned, keep in mind that kids these days are growing up in the data age. It's no longer the era where you could literally shred the document that had that child's information. Now, this is a scarlet letter stamped upon the ether, and nothing can scrub that clean. Out of the juvenile world and back into the adult, you'll see here that the National Employment Law Project says that somewhere around 1 in 4 of us carries a criminal record, a quarter of the U.S. population. According to the Department of Justice, that number may be closer to 1 in 3. And those waters just keep rising. They affect people in countless ways, these records. For example, employment, According to the Society for Human Resources Management, somewhere between 87 and 92% of employers conduct criminal history checks. Many of those result in automatic disqualifications if there's any mar on someone's record, regardless of the recency, regardless of the severity, regardless of the relationship between that offense or alleged offense and the job at hand. Housing is difficult to obtain if one has a criminal or publicly accessible juvenile record. Certificates and licensure, be it working for the Department of Human Services in a licensed facility or field, or practicing law. The ability to obtain government assistance is impacted by the presence of a criminal record, so that even if one can't find another lawful way of putting food in their belly or a roof over their heads, they're cut off from that help as well. The ability to obtain an education. The Common Application Form, the form that's used by more than 500 colleges and universities nationwide, asks the question, have you ever been convicted or adjudicated delinquent of an offense? Yes or no? Can you imagine your ability to access education limited to a checked box? Or the ability for your children or grandchildren to access that education limited to a checked box? Now, some colleges and universities may say that that is just one variable in a much larger algorithm in determining who will make up next year's new admissions, but I would ask that you consider the chilling effect that that question has on applicants who have a criminal or juvenile record, because unlike employment, with education, you have to pay to be denied. Those applications cost 20, 30, 40, 60 bucks a shot just to be told that you are not a good character fit. This at a time when there is no social science research that shows us that prior criminal history has any bearing on future campus safety, and at a time when countless research shows us that the ability to obtain an education is one of the greatest determining factors in reduced recidivism. We should be pushing kids into school at a time that we are locking them out. Immigration is impacted by the presence of a criminal record, both the ability to stay in the United States and petition family to join them. The ability to travel. I had a client once, a woman that come into the Council on Crime and Justice, who years before had been an active member of the Red Hat Society. For those of you who don't know, the Red Hat Society is comprised of women, primarily those over 55, who don red caps and purple jackets, and they volunteer together, and they go to theater together, and they have book clubs and debates together, and they have lunches and brunches and together, and every now and then they charter a bus and go to Canada together, which is what this particular chapter had done. Once they got to, the Border Patrol came on the bus and said, I need to run everybody's IDs. The women dutifully handed over their licenses, not thinking anything of it. Sometime later, Patrol came back on and said, you shall pass, you shall pass, you shall pass, you shall not. You see, what had happened was 3 decades ago, this woman had been accused of an offense. She was never charged, much less convicted, but that arrest was enough to bar her entry into the country of Canada. And so the sisters said, see you later, and left her at a gas station. Did I mention she's in a mobility chair? So here's this woman in her red hat and purple jacket in a mobility chair at the gas station, calling back home to have money wired up so she can return. And she said that wasn't the worst part. I think that sounds pretty miserable. She said the worst part was this. As that bus was pulling away, one of her sisters put down a window and said, I thought I knew who you were. As if what had allegedly occurred 30 years ago was the full sum of this woman's character. Not those volunteering opportunities, not the theater, not the book clubs, not the debates, not the lunches, not the brunches, not even the 4.5 hours that it took to take that bus from the hometown up to the Canadian border. None of that mattered. All of that was forgotten. All that mattered was that she had once been accused of something. And as preposterous as that sounds, and I think it sounds pretty ridiculous, think of how often we do it. How often someone's criminal record overshadows every other aspect of who they are. It happens every day. The ability to partake in the civic process is also impacted by the presence of a criminal record. And then, of course, there's a greater chance of victimization if one has a criminal record because of all of the things that I have listed above. So it's nearly every aspect of who we are and how we are in the world, from psychological to social, from personal to professional, all impacted, all confined and defined by our criminal histories, by things that we've done in the past, but not for everyone. Really, just for a few of us, just for 1 in 4 of us. What about the other 75%? What about the 3 out of 4 of us that haven't had to answer for past mistakes or acts every time we've applied for a loan or for school or for a job or for housing? What about the rest of us? I wanted to know if anybody would join me in this little experiment. So a couple of years ago, I had written up a flyer that said, "We are all criminals, what have you had the luxury to forget?" I then sent out that flyer through our social service network in the Council on Crime and Justice, but asked our network not to respond. I didn't want to hear from people that I already knew. Instead, I asked them to forward it on to their networks, their coffee clubs, their church groups, their colleges, and their neighborhood organizations. And to my unending surprise, the phone actually started to ring. So I bought a camera and a recorder. I hopped in my hatchback and I drove all across the state and now all across the United States, interviewing people in cars and bars, in diners, and quintessentially Minnesotan, on boats, anywhere where somebody might feel comfortable enough to disclose to me something that they otherwise had the luxury never to. I then took mugshots of those individuals, pictures that I hope relay individuality and personality, but of course without identity, and then placed the first 80 of the more than 250 of these interviews on the website at weareallcriminals.org. If you go on the website, you will see that there is a wide range of offenses, from quite serious, like aggravated robbery, to relatively innocuous, open bottle, that's carrying from one house party to the next, petty theft, that's failure to return a library book. The next one down was public urination. This gentleman now has a contract to work with the Department of Defense, some of the highest security clearance in the nation. Had he been caught, he would find difficulty getting a job at a gas station. There is also a range in the responses to the recollection of past transgressions. For example, this gentleman told me about a time that drunk one night he and his college roommates decided to liberate quarters within a double-posted parking meter. One drunken shot went right through that locking mechanism, letting loose $40 worth of quarters. He called it his $40 shot, and he laughed throughout the entire confession, if you will. Some people wept throughout theirs. Like this woman who told me about a time when she was working as a barista and she would pad her tips with bills from the till. As she told me this, tears streamed down her face. She said, "I can't imagine what life would be like for me now had I been caught then." Time and again, I heard from people who engaged in criminal activity so that they could feel like they were part of a social circle, like this gentleman who donated some of his FAFSA funds to help finance a drug ring. Or this woman who sold weed to frat bros and football players, just so that she could get a "hey, what's up" in the hallway. She said she was sick of feeling invisible. Time and again, I heard from people that recognize that crime is an event in life course, not a common or not a static characteristic of a human being. And then I also heard some truly heart-wrenching stories, or at least in my opinion they are. Now, this story you can read in full on the website, and I would ask that you do. The abbreviated version is this. When he was 15 years old, his family moved to an even rougher neighborhood than they had been in before. And within the first few weeks, he found himself mugged and beaten several times. After a while, he noticed that when he hung around a certain group of guys, the beatings stopped. So he joined the gang. Now, that didn't come for free, and the cost was exactly one Saturday day, when he was told that if he didn't pick up the lead pipe and hit another 15-year-old child, a boy who looked a lot like him, a member of a rival gang, that he himself would be beaten. He made the decision that he has regretted every day since, he said. He picked up that pipe and he hit that child. Had he been caught, he would have been charged with first-degree assault for the benefit of the gang. He would have been certified to stand trial as an adult. He would have been convicted. There, he would have entered the system and ended up eventually in prison, out of prison, in prison, out of prison, in prison, out of prison. He wasn't taught. He graduated from high school. He got a scholarship to go to college. There, at this Ivy League college with the gates closed behind him, he said he could read an entire math problem. He could finish a paragraph. He could, for the first time in his life, concentrate because he wasn't constantly checking over his shoulder to see what was coming next. His grades skyrocketed. He graduated from undergrad, went on to graduate school, and now has a PhD in biophysics. Now, I'm not saying that that would be impossible had he been caught. Chances are he wouldn't have graduated on time. He wouldn't have gotten that scholarship to a school. That Ivy League would have made him check that box, and chances are he would have been told that he's not a good character fit. And then every job, promotion, or internship ever since then likely would have denied him because of his criminal past. Now, make no mistake, I am also not saying that there should not be consequences. Absolutely there should be. And I'm not suggesting that we somehow conveniently forget the harm that is created by people all throughout the United States every day. What I am saying is that when we are constructing policies and responses to that harm, they must be rational. They must be reasonable. They must be proportionate. They should be merciful. And perhaps above all else, there must be an end. Because without hope, what does one have? We talked about the cost and we talked about the hidden cost. This is the human cost. We Are All Criminals seeks to remind us that while we have all done something that we're not proud of, each and every one of us, we are also all human and may be in need of a second chance. Sorry?
Don't worry about it.
Okay. But this project is also a commentary on the disparate impact of our nation's policies, policing, and prosecution. Many, not all, but many of the participants have benefited from belonging to a race and class that is not overrepresented in our criminal justice system. And some have been pretty straightforward about that. Others, like this one, approach the project in a different way. And because of that, she is one of my absolute favorite participants. By the way, I'm still interviewing people, so if anybody here would like to be my new favorite participant, please do see me afterwards. The reason I enjoyed this woman so much was because she came in not with a particular story in mind, but just an openness, a curiosity, perhaps even a little vulnerability. She said, I am in my 20s. A few years ago, I graduated from college. What do you think I've done? Tell me, what do you think she got away with? Shout it out.
Drug use.
Drug use, the answer was yes. What else? Shoplifting, the answer was yes. What else? Underage drinking. How did she get that alcohol? Prostitution, answer was no, but that is actually pretty common among recent grads that I've interviewed. It was a fake ID. She said it was my sister's. Does that count? Still counts. She also got 3 of the publics. Public urination, public indecency, public intoxication, public urination, I guess that's 4.
Tax evasion.
Say once more?
Tax evasion.
Tax evasion. I actually didn't ask her about that one, but there we go. Next time.
DWI.
DWI, the answer, very proudly, she said, was no. That was one of the few that she said no to. And the stories, it went on and on and on. And at one point, she was telling me about the theft, and it involved stealing when they would leave house parties in college. They would stop by a campus pizza by the slice place. And there were 3 employees working up front. Employee number 1 would take your order, employee number 2 would take your money, and employee number 3 would give you your slice. They would just skip employee number 2. So they would give their order, they would take their slice, but they wouldn't give their money. She said, technically it's not stealing since it was my pizza. We had a long talk about technicalities. But then she said, really, okay, fine, but does somebody get caught for something like that? And I told her about a client of mine who had stolen a sandwich from a lunch buffet. He was underemployed at the time. He was arrested. He was charged with a theft, pled down to a petty cut a check and thought he was done with it. He promptly lost his job. He couldn't find another. And now years later, he is living out of his car. Does that happen to everybody who picks up a petty misdemeanor theft? No. Would it happen to me if I did today? Not that I have any intention to, but if I did. Maybe it's hubris to say, I don't think so. Or maybe it's a recognition of that safety net that I have, how very exceptionally privileged I am, and understanding that that net doesn't exist for millions of people across the United States, but instead for millions they are hanging on by a single thread, and that record can be the thing that cuts it. Here's what I hope out of the project, that people see a bit of themselves in it. That you take notice of the context that you allow yourself. I was young, I was drunk, I was stupid. I was in a bad relationship, it wasn't my idea, I gave it back anyway. Whatever that context is, recognize that it may have existed for somebody who was caught as well. Now, it's perhaps not an excuse, but it is an opportunity to recognize a common humanity. I hope that some recognize the privilege that they've experienced and realize that not everybody is granted that same privilege. I hope that viewers reflect upon how very patently different their own lives may have been had they been caught, and I hope that it inspires people to take action. Now, it doesn't have to be some grand political scheme in which you do this. It can be something just in your own home, in your own neighborhood, in your own church, wherever it is. Just extending that kindness and that hope at a second chance to one of your neighbors or your friends or your colleagues would be a great step in the right direction. Because 4 decades of bad policies and practices have led to the mass disaster that we're dealing with now. And it's not just one policy or one practice that will undo that. But this is a true possibility within our lifetimes, that decline of people involved in the criminal justice system. I believe that it can happen. And I believe that the time is now. But perhaps right now, the best thing to do is to consider what your own chalkboard might say. What have you had the luxury to forget? What's your story? And if that story if that chalkboard were to be your mugshot, what would it overshadow in your life? Think, for example, of what was the last picture that you had framed. Was it your wedding or your graduation? How would that have been affected had you been caught all those years ago? If instead of that photograph, you had this one to remind you of what you had done. And then keep thinking, because chances are you've forgotten quite a bit. Thank you.
All right, hi everyone. I'm going to try to follow that. And I've been working with Emily for a few years now, and I always get the unenviable task of following that. But it works out good. It's a good partnership because I think Emily does a great job of sort of teeing up the issue that we're working on, and I'll jump in and talk about some of the changes to the Expungement Law and some of the work that we do at the Council on Crime and Justice to help some of those folks overcome the collateral consequences and the barriers that Emily was discussing. At CCJ, one of the things we do is we host numerous free legal clinics in Minneapolis and St. Paul and many of the suburbs, where we sit down with clients, answer questions about their records. Some of it's as simple as helping them understand these terms that are on the background check: stay of adjudication, stay of imposition. What do these dispositions mean? What were they intended to be able to provide for the individual in terms of a benefit? How can they talk about those dispositions in employment context so that they can hopefully actually benefit from what those dispositions were trying to accomplish in terms of protecting their record? and then talking about expungements and DHS licensing appeals, other licensing appeals, and some of the remedies that are available. So many of the stories that Emily uses, the stories about people with records that get juxtaposed against the folks in the pictures, actually come from the clients that we work with at these seminars. So I put together a number of slides. It is almost undoubtedly many more slides than I'm going to have time to get to in the last half hour of the presentation today. But I sort of did that intentionally, hoping that there would be, it could serve as a reference point. I tried to cite things with statute numbers. So especially the whole last section on alternatives to expungements and tips, that's something we probably won't get to, but it is there. And one of the slides in there is a resources slide that has information about our free legal clinics. You can find more information on that on our website, www.crimeandjustice.org, if you are working with somebody and you'd like to refer them to one of those clinics. So what I do want to be able to cover in this time is I want to do sort of a quick update on the state of our expungement law. We had a pretty significant change in the law that went into effect earlier this year. So I'm going to talk about expungement generally, sort of tee up what that change was, how it came about, why it was necessary, and what it did. And then I want to talk about some of the sort of emerging issues that we're seeing as the district courts, and actually currently there's at least one case that I know of pending at the Court of Appeals starts to work on those issues. And I should say, full disclosure, at CCJ we did file an amicus curiae brief on the one case that is pending at the Court of Appeals. So I'm going to tee up the issue. I'm going to try to stay away from sort of advocating for a particular position. All right, so the current law, it starts off with very simply, what are we talking about when we're talking about expunging someone's criminal record? And a lot of times when I sit down with clients, I think they have a concept in their head of a rap sheet or a singular entity, a singular source that has all of their records all in one place. My pet theory on that is that comes from the bail evaluation that is oftentimes their first experience when someone has a new case and is awaiting their arraignment hearing. There's a study done where someone actually combs through all of these resources to put together a singular report that makes it seem to the defendant like all this information is all in one place. But of course, that's not how it works. There are multiple players throughout the criminal justice process. Each of them collect their own information, store their own information, and at times disseminate it. So we have all of sort of the different places throughout the state, from the local police departments to the prosecuting offices, the courts, the BCA, Department of Corrections, and so on. And then beyond the government-held records, we have the privately held records, the data miners, the companies that are scooping up this information, maintaining their own databases, and either publishing it online or selling it in terms of the background checks. So that's sort of our universe of criminal records. And we'll come back to that when we look at what can be expunged and what can't be expunged. The basics of expungement law. So what is an expungement? I know when I was practicing, when I was first out of law school and practicing at the public defender's office in Ramsey County, I sort of had a vague idea what an expungement was, but we didn't really work on it very much, so I didn't have the opportunity to dig into it. So when I started working with Emily at the Council on Crime and Justice, one of the first things I did was Google it and found the Black's Law Dictionary website definition of expungement. And it said to erase or destroy something. And while that's the technical definition in Minnesota, that's not what it means. For the most part, expungement is just synonymous with sealing the record. It is not destroyed. In fact, one prosecutor that I talked to told me that when they are subject to an expungement order, they simply wrap red tape around the file and put it right back on the shelf. And so these records can be reopened. And there's a slide in a little bit that shows sort of the circumstances under which that can happen. The most common way that they would be opened, or the need for them to be reopened, would be if there's a future law enforcement need, if there's a subsequent prosecution or investigation or sentencing. We have 4 basic types of expungement law in Minnesota. The first one is actually in the BCA's portion of our code, 299C11. And that provides for sort of an administrative expungement that doesn't actually require the person to go to court. And that is available for individuals who have been arrested, so there's an arrest record at the BCA or the local law enforcement agency, but either have not been charged with a crime, or if they were charged, It was dismissed prior to a finding of probable cause. And then also they had no prior gross misdemeanor or felony in the 10 years prior to that. If they meet those requirements, all it takes is a letter to the BCA to get the record returned, is the language in the statute. And then we have our statutory expungement, Minnesota 609A, and that's where the reform is going to happen. And a juvenile expungement, also codified in statute 260B 198. And then the fourth type of expungement is based on the court's inherent authority. So the innate powers of the court that come to the court just by its very nature. And that's sort of the heart of where most of the legal action around expungements and the scope of expungements has occurred over the last 20 years or so. Let's talk about 299C11. I'll skip through that. So I want a quick hit on the expungement reform and why it was needed. And you'll see I've got my sort of tree of the branches of the government, which should remind everyone of 9th grade civics, I think. And this, it's sort of the separation between the three branches of the government are sort of really at the heart of the issue in our expungement law. And the courts had been sort of dealing with this, the Court of Appeals and through the Supreme Court for years, and really coming down to, okay, the court's inherent authority allows it to seal its own records. That's pretty clear. But what about these records that are held by other agencies, by executive branch agencies, the BCA and the police department? And the appellate court case law had kind of gone back and forth on that for a while, and at times there was favorable language that was being used to grant sort of full expungements that seal the court records and the executive branch records, but other times the courts were looking at the appellate court law and saying, no, this is pretty limited, we can only seal the judicial branch records. And all culminated in a case called State versus MDT a couple years ago. It came through the Court of Appeals all the way up to the Minnesota Supreme Court, and the result in that case basically put to bed the idea that the district courts had the power to seal executive branch records absent a statutory provision allowing them to do so. And so after State versus MDT, sort of what we ended up with was this. Here's our sort of universe of all the records that are out there. Here's what you can get sealed if you have a statutory expungement. Everything basically but the privately held records. But here's what you can get sealed if you only have the court's inherent authority to rely on. Just the court records. Everything else would remain. So obviously it's clear we wanted to be in the statute, in the arena of the statute if we were going to ask for an expungement. The problem was that at the time, Minnesota Statute 609A was very limited in its scope and its reach, and it basically just covered these three types of cases. The first were certain controlled substance offenses. This is basically our 152.18 disposition. It's a statutory stay of adjudication, commonly used in drug courts for first-time offenders for fifth-degree possessions. So there was a remedy for those folks. The second one was juveniles who were certified for adult court, although I've actually never seen one of these cases get expunged or really even heard of anyone trying. In general, I think the nature of the types of offenses that get someone certified to adult court is going to be a pretty substantial barrier to obtaining expungement. And then the third was basically cases that were entirely resolved in someone's favor. So no guilty plea entered, no admission of guilt, something like a stay of adjudication, which ultimately ended up with the case being dismissed, was still not resolved in favor. Basically, you had to have your case dismissed outright to have a remedy under the statute. So pretty limited. The vast majority of people, the people who plea bargain for anything on their case, even if they were charged with 4 counts and it was only the count 4 disorderly conduct that they pled to, and that was a petty misdemeanor, that whole case was still not going to be resolved in favor. No real remedy was available. And so that's sort of where MDT left us. The silver lining, I think, or at least from my point of view, the silver lining on MDT was that it made really clear that if we were going to have a meaningful expungement remedy in Minnesota, it was going to need to be created by our state's legislature. And so late in 2013, there was a lot of sort of pre-session work on this, pre-session work groups, and in the 2014 legislative session, we did get an expungement reform bill passed through the legislature with a pretty awesome bipartisan effort. And this is, in a nutshell, what it gave us. 4 new provisions, at least 4 new provisions that expanded the scope of expungement by adding new types of dispositions to the expungement statute. So the first type is stays of adjudication and diversion cases are now eligible for expungement, even though they're not resolved in favor. The person needs to have completed their program and then have a clean record without a charge for 1 year after completion of that program, and then at that point they're eligible under the statute, and the court has the ability to grant expungement under that statute, which covers all of the records that are out there. So similarly, we've got petty misdemeanors and misdemeanors. Again, they have to complete the term of their sentence, so they're going to have to complete their probation period most likely, and then have a clean record for 2 years after that. Gross misdemeanors after 4 years. And then there's a select list of felonies. There's a list of about 50 that have been added to the expungement statute, and there's a clean time period of 5 years for those. And sort of the story about how that came about was really the legislature went and took the bottom 2 rungs of the sentencing guidelines grid and said, okay, these are the felonies that have already been classified as the least serious, so that's what we would be comfortable sealing. And then they kind of went through with a red pen and cut everything else that made any of the lawmakers nervous, and we ended up with a list of about 50. A good number of those involve, cattle and things that we just don't see very often. I tried to sort of pull together a quick list of some of the common ones that we're seeing at our clinics, kind of on the ground. 5th degree drug possession and sale, criminal damage to property, aggravated forgery, fraud, check forgery, theft. So these property crimes basically. And you can see a number of them have a financial element added to them. And the reason for that is that the way these statutes are laid out is they have escalating penalties based on the financial amounts in question, what was stolen or damaged. And so for invariably across the board, it's the lowest felony level in terms of financial amount that is covered by the statute. What about juvenile records? So there's a little bit of an interesting story with juvenile records, because at the same time that MDT was decided, the Supreme Court decided another case called JJP, which was sort of an analog dealing with juvenile court records. And while the issue in MDT was sort of really clear, it was an inherent authority expungement. We knew there was no statute involved, so it really sort of teed up the issue of whether or not the inherent authority allows for executive branch records to be sealed. JJP was a little bit different because there was a statute in place. It was 260B 198. And at the time, it had stated that the court may expunge an adjudication of delinquency at any time it deems advisable. So we actually felt pretty good about JJP going into that case. We're maybe a little bit worried about the MDT case. But this seemed like it made clear that there was a statutory basis to seal all of those records. What we didn't know was that this term adjudication of delinquency didn't mean what we thought it meant. We thought it meant the sort of process of the case referring to the whole case. In actuality, the Minnesota Supreme Court defined it as applying only to the specific order, the specific act of adjudicating the youth delinquent. And so any of the other parts of the process in the file, from the charging petition that starts the case to the arrest records, or even in a case where there was a stay of adjudication for the juvenile, the statute didn't apply. So it basically did the same thing as MDT did to the adult expungement and left us with no remedy. So the legislature did step in with that and also clarified that 260B 198 was intended to cover all records relating to the arrest and delinquency proceedings. So the burden of proof, I've got a couple slides with that exact statutory language. I'm not going to read it to you, but you can take a look at it. Same thing with the factors that have been codified for judges to consider in deciding whether to grant an expungement. These are, I think, for the most part, what you'd expect to see in there. They look at the nature and severity of the offense, trying to define what risk, if any, remains to the public from this individual, and is there any chance that someone would get burned if this record is sealed. The length of time since the conviction is it's mentioned in those sort of clean time periods that are the threshold consideration, but it's also considered at the back end too. So I think that tells us that you have to meet the minimum amount of time, but just meeting the minimum amount of time might not be enough. If a judge wants to see a longer period of time that the person has demonstrated that they are law-abiding. Evidence towards rehabilitation, aggravating factors in the crime. Mitigating factors in the crime. I think that one is in some ways a little bit of a trap one. I have a lot of clients who really want to go into the mitigating factors of their crime, maybe going into those factors so far as to say, you know, I really didn't do anything here, and I only pled guilty because of my crummy public pretender, or my attorney told me to take the deal. And so oftentimes lots of mitigating factors. I think it's really important in those types of cases to help clients find a way to take responsibility for their role in it. After all, they most likely did plead guilty, say under oath that they did it. It's going to totally undermine their case if they want to come back and say this record should be expunged because I didn't do it. And then 6 is your sort of burden, your attempts to obtain employment and housing, and all the ways that the record is holding you back. Other criminal records going to come into play. Community involvement is going to come into play. Considerations of law enforcement and victims are going to come into play. Restitution was a little bit of a change that came in because prior to the expungement reform, most courts were looking at any outstanding restitution as being a barrier of completely barring an expungement. But the statute does clarify that restitution should be something that is taken into consideration, and if there are mechanisms in place to ensure that restitution continues to be paid after the statute is expunged, then it could still allow for expungement. And then 12 is just the catch-all. I'm going to skip over some of these other things. You can take a look at them. They're pretty well documented. What I do want to spend the last sort of 10 minutes on are some of the emerging issues that we're seeing the courts deal with. And so one of them involves diversion programs. In particular, programs like de novo in Hennepin County, and there are others in other counties where the disposition of the case that goes along with the diversion program is really functionally similar to a continuance for dismissal, because the defendant isn't required to enter any type of guilty plea. The case is sort of just continued while the person goes through the diversion program. What's interesting sort of about this is that prior to the expungement reform, that disposition, where there was no formal admission of guilt, had been considered, and the appellate courts had looked at this, and had considered this to be a disposition that was resolved in the petitioner's favor. And so they fell under the previously existing provision of the expungement statute, which had a couple benefits to it. It did not have a clean time period attached to it. It also had a favorable burden on the state, and had an automatic waiver of any filing fee. But the ambiguity that came about by the new statutory language is now we have this term diversion added to one of the new provisions. And so the question is something like Project de novo, should it be treated like a diversion, or should it still be treated like a case that was resolved in favor? And again, it has those implications for the waiting period and the filing fee. Another emerging issue, and this is the one that I know there's a pending Court of Appeals on, a pending Court of Appeals case on that we filed an amicus curiae brief on, involves a stay of imposition, right? So with a stay of imposition, the person is charged with a felony, usually or may result from a plea bargain. Let's just use that as the paradigm and say the defendant pled guilty to the felony, was sentenced and put on probation for a felony time period, or time period applicable for a felony, maybe 5 years. But because the judge did not impose that 366 days or more, left that sort of step undone, the law allows this opportunity for the defendant to earn themselves a misdemeanor, and per statute 609(1)(3), subdivision 1(2), when the person is discharged from their sentence successfully, the conviction is now deemed to be a misdemeanor. So the question for the expungement statute, which provides a remedy for misdemeanors, but a much more limited remedy for felonies, is does this count as a misdemeanor? And there's some case law, State versus Franklin, sort of gets around this issue a little bit that in the context of career offender statutes or other sort of collateral consequences, and there's some other sort of case law on it too. So that's something that the Court of Appeals will be looking at soon. And the third major ambiguity, I think, involves how exactly courts are supposed to apply this clean time period. And one thing, this isn't really an ambiguity, but sort of a quirk of the statute that it's worth pointing out, I think, is that the new provision that applies for diversion and stay of adjudication requires that that clean time period have no new charge. It specifically calls out having a new charge be the disqualifying factor, where the other three provisions, the misdemeanor, gross misdemeanor, and felony, actually use the word conviction. So that's a little bit of an oddity, but it is something that's in there. And then for these other offenses, the misdemeanor, gross misdemeanors, and felonies, the ambiguity arises when we're talking about how do we apply it when there's more than one offense. And the language specifically says basically no new conviction since discharge of the sentence, which seems like it sort of situates the relevant time period in the past, in those years immediately following the discharge from the sentence. You kind of think of it as a spotlight on the date that the person was discharged, looking forward in time. And if there is a new offense within that time period, then it would seem like the previous offense is no longer within the scope of the statute. And that I think is actually contrary to the legislature's intent with the Expungement Law, which was really to situate that spotlight on the date of the petition and look backwards in time, so as to say that you have to have a clean record for X number of years before you ask for relief. But there's definitely some ambiguity in the language that was chosen to be used. The advantage of the latter is that it is a more simple analysis. The disadvantage of the former is that it leads to what we're calling the Winter Olympics rule, right? Where somebody can commit a new offense, every 4 years, for example, and all of those will be expungible throughout their entire life, at least technically expungible under the statute. Whereas the one person who commits two back-to-back, maybe because they're arising out of the same sort of circumstances, could have relief barred for the first one. How am I doing on time?
5 minutes.
5 minutes. So a couple other emerging issues. The legislature gave us this provision 609A.025, which was intended to sort of streamline the process and allows for an expungement to happen without a petition being filed in situations where the prosecutor has sort of agreed to that. And so that's something that I've seen taken advantage of in a couple of circumstances. Fortunately, we didn't get much guidance into sort of what the process would look like for that, so courts are sort of left to figure out exactly how that works. And then it leads to a particular challenge once DHS records become involved. So the interesting thing about DHS records is that they are executive branch records. They do fall within the scope of the expungement statute, but there is particular language both in DHS's code 245C08 and also in the expungement statute that specifically say that notwithstanding an expungement for a record, DHS may still access it. It can be opened automatically so that they can access it and they can use it for their disqualification considerations unless they receive notice of the petition and they were included in the expungement order. So it basically reminds us that we have to make sure we have DHS at the table. And one of my tips in the slides I'm not going to get to is just always serve DHS because you never know when that background check might happen. But notice that the statute specifically says that they have to have notice of the petition. But this new provision allows us to expunge a record without a petition. So it's unclear whether or not that would cover DHS or how you bring DHS into that conversation. And then the last sort of emerging issue or item challenging the courts is what to do with traffic records and DWI records. And as a general rule, I think even in sort of the considerations under inherent authority law going back, we saw courts being pretty cautious and not, for the most part, not very willing to seal DWI records. I think there's a couple things at play here. One of which is that these records are sort of seen as not carrying the same type of stigma as your theft or your assault or something like that. I think in many cases that's true. DWIs are pretty prevalent and common. And then the other thing working against it is that there's a separate statute that requires that the Department of Vehicle Services, the Department of Public Safety, indefinitely retain that record. So the question is, does that bar expungement of that driving record, and what, if any, benefit is there to an expungement petitioner if we're not sealing that driving record? So there's some hurdles there. On the other side, sort of the argument is that it's, these are just misdemeanors, or oftentimes they're just misdemeanors, or gross misdemeanors, and the statutory language doesn't exclude them. So, if you're able to show a particularized burden, if you're able to tie that burden to the DWI record, then it might be worth trying to get the DWIs expunged, and we'll just sort of have to wait and see what happens with that. And then the last bullet point on here is actually a little bit outdated. There was a provision in the statute at the time that it was passed that exempted all domestic violence offenses, but that provision had a sort of sunset period on it for last summer, for July of last year. And the idea behind that was that there were some concerns amongst the advocates for victims of domestic violence that there might be some unanticipated consequences for victims in terms of being able to use these records or reopen these records in family court proceedings or other situations like that. And so the thing was, the advocates for victims were in support of the bill, because it turns out that oftentimes victims of domestic violence end up with criminal records themselves. But they just wanted to have one more legislative session to be able to iron out any of those kinks. And it turned out that in 2015, no changes were made, and that provision has since expired. So I think I'm probably right up at the end of my time. Thanks, everyone. I will stick around if anyone has individual questions that they want to run by me. My contact information is at the end of the PowerPoint, so if any questions arise, I'm always happy to hear from folks and help folks work through some of the implications of the new statute and collateral consequences just in general. Thanks, everyone.